Rahul. Along with me is my business partner, Emily Neumann. Every Tuesday, Reddy Neumann PC does bring in immigration updates. Emily, what do we have today to discuss?
Yeah, we want to talk about the continuing layoffs that we're seeing and how they impact immigrants, particularly compared to other people, depending on where they're at in different processes. I feel like over the last couple weeks here, the majority of the consultations our office has seen is from people that are getting laid off and need to understand the 60-day grace period, how it impacts a perm, an I-140, and pending extension, a 485, and all those things. We also want to talk about how you can effectively advocate for immigration reform. We have the EAGLE Act that was introduced finally. We got the text of the bill, and what happened last time, the last several times that this bill has been introduced, how can we get it across the finish line this time around? And then keeping an eye out for companies that may not be in compliance with immigration laws. How can you keep yourself safe, avoid issues with your own status that might be caused by a bad actor? Lastly, dealing with USCIS when they lose a document, when there's an error, when there's processing delays. What different options do you have to try to get those corrected, and what is the most effective?
Emily, first thing is that let's discuss about the layoffs if it is in a OPT student stage. We'll discuss in H1B, L1, and then we're going to discuss in the adjustment of status. Emily, in the OPT period, there is two periods. One is the OPT period, which is after they complete their graduation, they get 12 months of OPT. In that OPT period, people are allowed to do paid jobs. They're also allowed to get training without paid. Is that right, Emily?
Right. As long as their company is in compliance with the intern rules that are put out by the Department of Labor, it can be unpaid during that time.
So even if they don't get paid, no paycheck in the period of time, they can still be legally staying in the United States. So, for example, if they lose, if they're working with Microsoft on OPT and they get laid off, they can go to some other companies that are offering unpaid internship in the relevant field, and it's perfectly okay for them to do it. Is that right, Emily?
Correct.
And if they cannot do that, I mean, they can't get a internship job, they can't get a paid job, how many days of unemployment is allowed in the OPT period?
Up to 90 days. So if you've not hit that limit, you can take some additional time to continue looking for other roles. You could even consider, contacting your school back to maybe there's a professor that you can help with a research project that they're doing. There are a lot of things I think that you can do, and it doesn't have to be full time during the initial 1 year OPT time.
I see surprisingly so many universities offer the internship jobs, Emily, for the students. So that's a very good advice that you've given, that they should always contact the university professor to see if there is any internship jobs. They can be helping the professors in teaching or something in the same relevant field. That's a very good idea. Now, if ever you are crossing the unemployment for more than 90 days, though, we do not recommend that you go to some agencies, get pay them and get any experience letters which are fake. They are not proper. We have seen people getting deported for that reason, so don't get involved in those things. But you can consult a lawyer if you're crossing the 90 days, what are the options that is available. As Emily has suggested, going to an internship, unpaid internship is fine, or even if you go to the university, you get unpaid internship with the university is fine too. Emily, coming into the STEM extension, which is given after the 12 months, if the people have the STEM degrees, they get 24 months in addition to the 12 months. They apply the employment authorization. And what if they lose the job at that period of time? What are the options available?
Yeah, so there is an additional period of unemployment allowed for a total of 120 days over the 3 years. So if you've not used up that time, you can use that time to look for another job. The STEM OPT becomes a little more difficult because your employment is limited to E-Verify companies. So you have a slightly smaller pool of companies that you can look to, and the position does have to be paid, and it does have to be at least 20 hours per week.
Did you say 20 hours, Emily?
Yes, at least 20 hours per week. So part-time is still allowed, but it has to be no less than 20 hours per week. Definitely you can look in areas outside of where you're currently living. Remote work is certainly possible during the STEM OPT time. And again, you can check with your professor, check with your university to see if they have any potential. But the most important thing is not to get desperate, because when you get desperate, you tend to do stupid sometimes. And we don't want anything that you do at this point out of desperation to negatively impact your future, such as using one of those companies that people did before, the Integra, the AZ Tech, or whatever it was, the Wireclass. Those companies were there when students were hitting the unemployment limit, and they were offering, hey, we'll give you an offer letter, we'll say you worked for us, we'll do all these things, and all of it was fake. And a lot of people ended up with misrepresentation, fraud findings, and can't get the visa to come back to the US ever. So please don't let something like that happen to you. You can always look in other countries. You know, maybe the US isn't right for you right now, given that situation. It's better to stay in compliance and potentially leave the US than do something that's going to impact your ability forever in the future.
Emily, when they are in H1B, if they get laid off, though, what are or L1, they get laid off, what are the options that they have?
Yeah, so it's really important to know whether the I-94 is valid or not. So assuming you've got an approved H-1B and your I-94 has not yet expired, you do get the 60-day grace period that allows you to look for other jobs or look into filing a change of status. So for L1, it's much more difficult because you can't really look for other jobs on an L. There's no portability for L1 petitions. So you're going to be looking at, is there some other visa category that I can qualify for? But for H1s, you do have portability, so you can be looking for that new job within the 60-day grace period. If you're hitting the 60-day grace period and have still not found the new job, that's where you can look at filing a change of status to H4, maybe if your spouse is on H1B, or a change of status to B2 to request additional 6 months to continue your search. That allows you to change status back to H1B without having to leave the country. But beware that you do have to have the valid I-94, meaning it's not expired yet. And a lot of people question, well, what happens if my company is withdrawing my H1B because they're terminating me? Does that impact the grace period? And it does not at all. So just be aware of that. That's a normal part of a termination situation. The company is required to withdraw the petition or notify USCIS of the termination. They're required to notify you of the termination, but they're also required to offer to pay your return transportation home if you're choosing to leave the country. So if they're not doing all three of those steps, the company is not in compliance. So be aware that having them withdraw the approved petition does not have any impact on your ability to use that grace period.
Emily, when it comes to the adjustment of status, when people have an EAD, though, and assuming that it's been more than 180 days that they have been filing the 485 application, do they still have 60 days in the adjustment of status EAD to change the job to a different company?
No, they don't. That's the odd thing. There is no 60-day grace period for a pending 485 or an EAD. Once the 485 has been pending for 180 days, you can use that EAD to move to a new employer and basically take that process with you. But there's not really a gap between employment that's contemplated by this AC-21 regulation. So if it's taking time to find that new job to where maybe you're being called in for an interview or you get a request for evidence asking for a supplement J, that's where it can be very risky if you don't have the new job at that point. We would definitely recommend contacting an immigration attorney to discuss options.
Emily, anything else to discuss before I go to the next topic?
Yeah, a lot of people question, well, what if I have my H1B extension pending? Do I still get the grace period? if the layoff happens during that time. And that can be a very risky scenario because if your I-94 has already expired, you don't get the grace period. And if your company withdraws that pending extension, it does put you out of status. So that's something where you definitely want to speak with an attorney. Another question we get is, what if my perm is pending? Do I get to keep that priority date? Can the company still proceed with the process? And the perm itself, there's no requirement for the company to withdraw it like there is for an H1B, but it is within the company's rights to withdraw it. They may do that, or they may just let it process, and once it gets approved, let it expire by not filing the I-140 within 6 months. For those that have an approved I-140 and are then laid off, you still get to keep that priority date when you work through the green card process with your new employer once you land that new job. But you want to make sure, if at all possible, that your I-140 is not withdrawn within 180 days of getting the approval, because that can negatively impact your ability to get H1B extensions based on that approved I-140 and H4 EAD for your spouse.
Emily, when it comes to the advocacy for the immigration, though, I know a lot of the Indian people who have been waiting in the priority date for a long period of time. They're very discouraged. They have written letters. Things have not moved. However, they're a little bit short-sighted, though, even though there are some victories that they have got when they have advocated, though. For example, Emily, in the second year, in 2022, when they were about to waste about 100,000 green cards, they made a very big noise. In fact, they made such big noise, I don't know if some of the big official, I don't want to name that official, but he resigned from the State Department. They used to do a show in the YouTube, and they stopped doing the show, and they used to have asking opinions or asking letters. So many of our people wrote the letters that we drafted. They stopped doing that show now and resigned the job. I'm not going to say that if it's because that reason, but it could be contributed to that. And in that year, they used the entire quota where they gave all the green cards that are available. The people got the green cards left and right. So many people got the green card, even if their priority date was, 2014 when it was current, they gave the green card to those people. But of course, some of the 2011 or 12 people were left out, but 2014 people were given the green cards at that point of time, Emily. Yet they are short-sighted. They say, okay, the priority date, we advocated for not counting the family members. We advocated for the Congress to remove the per country cap. We have not successful. They keep on whining. Is there any hope? And how do we encourage these people to keep on doing it? Because we see success in advocacy. We have seen that when it comes to the DACA kids, where there are 1 million children who came into the United States when they were under 15, and they were who were not having an employment authorization, who were not having a legal status, they all got their employment authorization through the advocacy efforts that these children have done it. Yet our guys, one thing is that they're very comfortable with the H1Bs, they're very comfortable with their I-140s, they're very comfortable with the H4 EADs, they're very comfortable with the fat salaries that they're getting it. But they're very hesitant in participating in advocacy, except they'll put a word out, say, we did it, it didn't work. What do we say to these people, and how do you encourage these people to participate in advocacy?
Number one, you have to recognize that there has been progress. Going back, yes, this bill has been around for over a decade, but every time it's been introduced, it's gotten closer and closer to actually passing. It's gotten more and more co-sponsors. It's got more people advocating and supporting it. It's gotten modified based on things that people on the opposite side were saying about the bill in order to try to gain more support for it. So no, the bill is not passed yet, but every single time there has been progress. And if you give up at the last second, you don't know when the next time it's actually going to go through. So the most important thing is don't give up. You have to persevere. You have to keep at it. Don't get discouraged about it. Keep going. Beyond that, don't rely on other people to do it for you. I see so many people saying, well, why aren't attorneys helping us? Why aren't they, why isn't AILA supporting this? And why isn't this group? And why isn't that group? Well, it's your job to get an advocacy group together to get allies, to get people to support you. And when they do, don't blast them if they're not doing it the way you want them to. I mean, you turn off so many people by the way you're treating people on social media based on what we've seen in the past. So when you get those allies, when you get those supporters, work together, not against each other. But the biggest thing is you've got to contact your congressman, you've got to contact your senator. Best thing to do is actually to meet with them. And I only really see one person on Twitter that's going around and trying to meet with people in 50 states. So great job to that, but people aren't joining in that. They're just, again, relying on someone else to do it. So do it yourself, get your colleagues to do it, get your friends to do it, get your company to help support and advocate for this. But you've got to be the one to be writing the letter to your representative. I did post on Immigration Girl today, immigrationgirl.com, a sample letter for you to send to your senator, starting with the Senate because this bill was introduced in the Senate and it's got to go through the Judiciary Committee first. So I did give instructions there. I've added some additional things that you can include in your letter. So there's a new map the impact that the American Immigration Council put out, where you can actually click on your state, even on your city, your metropolitan area or your county, and it will tell you approximately how many immigrants are in that location, what amount of taxes they paid, what is their spending power, and how many immigrant entrepreneurs are in that area. All of those things can be used to explain how this bill is going to help the economy, how it's going to help these communities, how it's going to help bring in more U.S. workers. And on top of that, this bill, for the people who claim that, you know, giving all the green cards are going to hurt U.S. workers, well, guess what? This bill actually has more protections for U.S. workers than what we currently have. So not only do you need to be contacting your representatives, but you've got to be out there informing people, educating people, getting rid of the misconceptions about this bill and doing it in a respectful way. You've got to empathize with the other side. There are lots of rest of world people who are going to say, we don't like this bill. We don't want to have to wait. Why should we have to wait? Well, you've got to empathize with that and understand and say, yes, we need more reform, but this is a first step. This is something that's about fairness. It's about equity. It's about merit-based immigration. It's about the people that have the similar qualifications should get the green card at the same time, regardless of where they're from, if they started the process at the same time. It's your job to get that information out. And if you think that just, you know, retweeting things on Twitter or contacting your congressman by posting something on their Twitter feed is going to work, this is never going to pass. You've got to do more, put the effort in to go above and beyond just social media.
I've seen the DACA kids going speaking in the churches, going speaking in different events, speaking with the congressman. These kids going there and speaking with them makes a lot of difference. Emily, for the rest of the world, this bill has provisions where especially those people who are in the pipeline, though, does not affect them significantly. Though. Yeah, down the line, 10 years, people who may be coming at that point of time, it may affect them significantly. But for the people who are in the pipeline, who apply for the labor certification, it doesn't affect them significantly because there are some provisions that they've been given. And when people are requesting that, don't tell that we need favors. We don't need favors. We just want to be treated equally. That's the request that you should be making. As Emily has pointed out, that if some opposition is going to come, don't try to go against them. Empathize with them. Try to speak with them. Don't not go attack them. That's not needed for you. We need their support too. Even when you speak with the congressman, if the congressman is opposed to that, don't just try to offend the congressman, though. You need to speak with them in love format to get them convinced to your way and to make them understand the pain that you're going through, the discrimination that you're going through. I'm going to go to the next topic, Emily, unless you have anything else to discuss.
Yep, we can move on.
You know, we see time and time again, Emily, when people fall into the trap of these bad companies, Emily. Bad companies, they're clearly visible. These people apply for the job. Okay, I'm going to apply for your lottery. I'm not going to charge you any money. They just apply for the lottery. I'm just giving them the passport. Am I doing anything wrong?
For sure, because you have no idea. I mean, the company needs to vet your credentials. I mean, what kind of company in today's market is going to hire someone sight unseen, no interview required? I don't need to look at your education or your resume or anything like that. All I need is your passport, and I'm going to put you in the lottery, and I'm not going to tell you what job I'm hiring you for or what kind of work you're going to do. Those are all red flags. You need to definitely look on myvisajobs.com, see how many petitions these companies are filing. A lot of times you'll see, I mean, you can see the work location listed on all of their LCAs. So there's a pattern. You'll see 2019, they filed 5 LCAs. 2020, they filed 100 LCAs. 2022, they filed 300 LCAs, and they're all for the city and state where the company office is located. Well, Google that office address. You can see it's like a one-room shack, and they filed 300
No, Emily,
LCAs.
it's a PO box. Sorry, it's a PO box.
Yeah, exactly. PO box. So those are all red flags. Of course, it's a red flag if they're asking you to pay them money in exchange for them processing your visa, but also if they're saying that they're going to do a wage that is below what is normal for the market. If they're telling you, well, it's, you're really a level 3 prevailing wage, but I can only afford to pay you level 1, so we're just going to file it level 1. Or if a company says, well, we'll just say that you're working in this other location that has a lower wage requirement, but you can really just stay where you are. Or we're not going to file an amendment because you've moved to a different project location. We'll file it in the future. It's okay. We can file it later. No, that they need to actually be in compliance, because everything they're doing that's not in compliance is hurting you. It doesn't just hurt the company. Yeah, the company can get in trouble for all those things, but you're the one that's going to lose your status. You're the one that might not be able to get a visa to come back. So don't let these companies take advantage of you in your desperation. Again, don't get desperate. Desperate people do stupid things. Don't let that happen.
And also, when you are working from home, though, please, if your home is not listed within the MSA of the LCA, before you start working from your home or remote location, which is not within the same MSA, you have to file an amendment. If somebody is telling you, the company is telling you, we don't need to file an amendment, no, you have to file an amendment if your MSA of where the remote location falls outside the LCA. For example, if your office is in Dallas and your home location is in Plano, they both are in the same MSA. So if you're going to move from office to Plano, you don't need to file an amendment. But if your office location is Dallas, but now your wife got a job in Florida and you're going to move with her to Florida and start working in Florida, before you move, you need to file an amendment, not after you move. We see that time and time again, this mistake done by the employers and employees, that's going to bite you very heavily. And it's you have to make sure that your company is also complying with the laws, though. But because as Emily has pointed, if they don't do it, you'll get punished. One of the other mistakes that we see that some of the companies do, and they tell you that they are going to give you some percentage of it, and that's what they do, Emily. So when people are moving from student visa to H1B visa, Emily, of course, they will be subject to extra tax of approximately around 6 to 7%. So they come to these people, look, you don't need a H1B change of status. We will get you the H1B. So we're going to make the 7%. I'm going to give you 3%. I'm going to make 4%, or vice versa. Now, this kid is happy because he's getting more money than what he's getting more money, but that's not right. The reason is that if you are an F1 visa and there is no change of status with the I-94 approved, though, technically you're not counted towards the H1B number. So if tomorrow, let's say this ABC consulting company filed an H1B without consular processing, without the I-94, now you got a job with Apple, you want to move, you're technically not counted towards the H1B number because you don't have an I-94 number. Then what you have to do is that at that point of time, you have to go to the lottery system again. So please, if you are in United States, if you're eligible to file the change of status, go for change of status with the I-94. Don't worry about the pennies. Believe me, I cannot guarantee that when I see the people 40 years age, of all the people who are in IT profession, every damn guy is a millionaire. Believe me, every damn guy is a millionaire. And you are going to be there. Don't fight for these pennies. Go for the millions. You will win it. Anything else,
All right,
Cindy?
last topic for today is troubleshooting when things go wrong with USCIS. I mean, I feel like every day we're getting some document got lost in the mail, or they made an error on an approval notice or a receipt notice, or just processing delays. What do you do when that happens? What steps can you take? What are the different ways to correct it? So first, one of the things to be aware of is who can actually contact USCIS. So if we're talking about an I-129 petition, which is for your H1B, your L1, your O1, anything that's filed by the company, or an I-140 petition, unless it's a self-petition I-140, only your company or the company's attorney that filed the petition can contact USCIS for issues with those. So a lot of times questions we get about, oh, I filed my H1B renewal in premium and my wife's H4 and H4 EAD all together. My H1B got approved in premium, but the H4 and H4 EAD are still pending. You know, what do I do? Well, in that situation, premium processing is the right place to contact, but you as the employee cannot contact premium processing. It's only the company or the company's attorney that can. Otherwise, it's got to be your spouse who's calling customer service, and they're just going to say, well, there is no premium processing for an I-539 and an I-765, so there's nothing we can do. So it's got to be the company or the company's attorney reaching out to the premium processing unit, reminding them of the settlement agreement that USCIS agreed to, saying we're going to process them all together if they're filed all together. Sometimes you've got to get a little bit aggressive on that, but again, it's got to be the company or the company's attorney that's willing to do that. Other things that happen, they mail a document like an approval notice or an advance parole, and it doesn't reach you, even though your address is correct. And they just throw their hands up in the air and say, well, it didn't get mailed back to us. There's nothing you can do. That's a situation where refiling may be your only option, which is terrible. But once it's refiled and you have that receipt number, you can try to do an expedite request, arguing that it was USCIS error that the original document got lost in the first place. Other errors can be sometimes dealt with through the contact center, but I'm finding more and more often that the customer service is getting more and more useless. The last time I called them and I asked to speak to a live agent, they actually threatened me and said, if you keep asking, this is the computer saying, if you keep asking to speak to a live agent, we will disconnect the call. And of course they did, after I'd been going through this phone tree for 10 minutes already trying to talk to a live person. So then I tried the Emma chat. And when I did it last week, I get through everything and it finally says, the system is down, we can't help you. I tried it again today on another case, and they said, well, we cannot access anything about your case right now. The case online system is down, apparently. Try again in 2 to 3 hours or in 2 to 3 days. So it's just pointless to even try to contact them. So that's where the ombudsman can be of assistance, but just be aware it can take 6 weeks for them to deal with the case unless it's something super urgent that they have set priorities that they'll get back to you right away. Next option is your congressman's office. They can help with things like transfer of underlying basis getting stuck, or documents not getting delivered sometimes. Lastly, court. Go to litigation, especially for processing delays, or sometimes incorrect denials can be dealt with in court. Kind of your last option is filing an appeal or a motion to reopen or a motion to reconsider.
Anything else, Emily, before we go to questions?
I think we can go to questions. Let's see here. Okay, Rajit says my EAD and AP is valid till February 2024. Applied for the renewal and got the 5-year combo card approved, but I was out of the country. I'm going to be returning in December 2023. Let's see, is my new renewed AP valid? So because you're coming back before your current AP expired, it is okay for them to approve your renewal AP even if you are outside the country. So traveling does not impact a renewal AP that's in process as long as you're coming back before the original AP has expired.
My friend's H1B got approved first and B2 later on. Can he do the Margarita switch or another H1B is to be filed? The best solution for him is the Margarita switch. Filing another H1B is too costly, too expensive, too risky, and definitely not worth. Margarita switch is the easiest method. WM asked this question. Let me explain what a Margarita switch is. That you just have to go to Mexico, you come back using the I-797, which has a valid I-94. Even if you don't have a stamping to come back into the United States, if it is within 30 days that you travel to Mexico or Canada and then you are coming back, you don't need a passport stamping to come back. You can use the H1B that has the I-94 to come back into the United States. WM has this question. He and his wife are a green card holder. His wife is going to travel to India for more than 6 months. Does he needs to file an I-131, which is also used for re-entry permit that will allow people to stay up to 2 years outside the country? I would recommend that if she could please have her come within 180 days. If you think so that she cannot make within 180 days, I want you to consult a lawyer because there are some negative consequences. Filing an I-131 is easy, but the problem is later on the citizenship will be an issue too. So I would want to suggest, first thing is that if you can avoid the lawyer, always good to avoid the lawyer. And that is by coming within 180 days, you avoid the lawyer. But if you can't, I would strongly recommend that you contact a lawyer, know what are the minus points of it, and then if you still want to take a risk of filing an I-131 and then come back after 6 months, that's up to you though. But definitely contact a lawyer for it.
Another Margarita switch question. This is from Jancy. My H1 is valid till 2025. I applied for an H4 and H4 EAD with my husband's H1 extension and premium. What happens to the H4 and H4 EAD if I use automatic revalidation to enter using the H1? Can I re-enter later in H4 and use the EAD? Yeah, so if you have an H1B approval notice with an I-94 that is not expired, and you have an H4 approval notice with an I-94 that is not expired, and you have an EAD that goes with it, you can enter on H1 using automatic revalidation. And if you later decide you want to switch back to H4, you can exit, come back on H4, and that EAD kind of gets revived because an EAD remains valid unless it either expires or USCIS revokes it. So the fact that you went out of H4 status for some time does not make that EAD invalid. It's just you can't use it because you're not in H4 at that time. But if you later get back to H4 by traveling and using automatic revalidation, then that EAD comes back to life and you can use that again.
Emily, I have this question from Dr. Prasad. I may need your help in it though. He filed EB1 green card and then got the I-140 approved. Seems to be that he has done the consular processing. It's documentary qualified, but the dates moved back right now. So they can't issue, they're not issuing the green card because they used up the EB1 numbers. Now, what other visas he can apply though? He most probably doesn't have an H1B. He's not eligible for L1. O1, he probably is eligible for O1 because he is qualified for EB1A. Most probably he will be qualified for O1 visa. Do you think so there will be a problem because O1 requires a non-immigrant intent? He already filed an I-140, Emily, to come into the United States?
Yeah, O1's kind of a weird quasi dual intent where it is a non-immigrant intent visa, but the Foreign Affairs Manual, the FAM, clearly says that simply the fact that you have an approved I-140 or filed an I-140, that by itself is not a reason to deny the O1 visa. So I do think it's still possible. Of course, you have to be prepared to explain and document your having a residence abroad that you don't intend to abandon and that you intend to leave the U.S. at the end of your stay, but that I-140 approval itself does not disqualify you from the O1 visa.
Shalini has this question that that will there be a third lottery for the H1B? We are expecting a third lottery. Somewhere from now to December 15th or so, we are expecting a third lottery. Question from SK. His I-140 was approved in January of 2023. Now he wants to move the job to a different company. Will there be any impact for the I-140? This question comes so frequently to us. The question here is that, first question that we get is, some people say is that, can a company withdraw the I-140 after 180 days it's been approved? That question comes, and some people argue you cannot withdraw, some people argue you can withdraw. Now, there is truth in both the things. Here is the issue, guys. The company can withdraw the I-140 after 180 days, but it won't have any negative impact on you. So for example, in this particular gentleman, his I-140 was approved in January of 2023. Right now, we are in November of 2023. If the company withdraws the I-140 approval right now, he can still use that I-140 approval to port the date to a different company. He can use that I-140 approval to use for his wife's H4 EAD approval. Even though it's been withdrawn, they can still use that to file the H4 EAD approval. You can use the same I-140 approval to move to company B, and from company B, he can move to company C without company B having an I-140 approval. Using company A's I-140 approval, he can move to company C, company D, company E, company F, all the way to Z. Okay, you can move all those companies still using the company A's I-140 because it's not been withdrawn within 180 days. The key point is, if it's been withdrawn within 180 days, he could not have used it to move to company C, but here it's been withdrawn after 180 days. So he has no problem, none whatsoever at all, using that I-140. You are free to go right now to a different company.
JJ says, if someone gets the green card with EB-5, do they have to be inside the U.S. for more than 180 days and should not be outside the U.S. for more than 6 months? That is correct. So any kind of green card, regardless of whether it was EB-1, 2, 3, 5, family-based, once you are a green card holder, you have to maintain your residence. The whole point of getting the green card is because you want to be a permanent resident in the U.S., not living abroad for 6 months at a time. So yes, you still need to remain in the U.S. and not take trips outside the U.S. that are more than 180 days in order to avoid possibly abandoning your green card.
Vikalp Gupta from YouTube has this question. He filed his 485, his date backlog. Now he got an RFE for a medical. Does it mean that they're going to issue the green card? No. Unfortunately, no. They can issue the medical RFE. What if you have some communicable diseases which we don't want you to stay in this country? I mean, hopefully you don't, but out of thousands and thousands, there may be one person. So definitely, even though the priority date is not current, they can call you for the interview. They can issue an RFE for the medical. It's nothing wrong with it. So you please comply with it. Don't argue with it. Otherwise, you'll get a denial. And no, unfortunately, they won't issue the green card for you.
Kriti says, I'm on L1A. Priority date is May 2022. Both the I-140 is approved. 485 is, I'm assuming, pending, and EAD's been approved for over a year, but the AP is still pending after a year. What is the way to expedite? And it says, I've traveled to India after applying for the AOS. So I think that AP is gone, even though it's still pending because you traveled while it was pending. It's going to be automatically abandoned and denied. So your next, you should have filed a new advanced parole I-131. Do that as soon as possible, and then you could potentially try to litigate it if you're seeing long processing times. But the things that are being filed right now are being approved much faster than things that were filed 6, 7, 8 months ago.
Emily, does the rejection happen even if it's an extension of an advance parole when you travel, or is it only the first advance parole that they rejected?
It could only happen on an extension if while you're outside the country, your initial advance parole expires. So if you travel and come back with a pending extension, but your initial one has not expired yet, then it won't be abandoned. Madhav says, can someone on H4 EAD have two jobs at the same time? What if I work Monday through Friday at one organization and then Saturday with another part-time or on-call? That's totally fine. You could even work two jobs Monday through Friday, work 80 hours a week. That is no problem at all when you're on H4 EAD. You can work as much or as little as you want.
Kedar has this question: can he apply the compelling circumstances EAD when he's already having a job? That's a very weak point. Why do you need it? Compelling circumstances EAD question will come in. When you are showing that you need a compelling circumstances EAD, you are telling the USCIS, I need this EAD to support my family to stay in this country for some compelling circumstances really, but you already have a job. How would you say that? So it becomes very weak. But yeah, if you're contemplating that you're going to lose the job at a certain period of time with a reasonable certainty, I think so you may be able to get a compelling circumstances EAD, but it will still be a weak case though. Raghu has this question: can the GCEAD person work remotely outside the MSA of where he was working previously? Absolutely not a problem. The problem was only for the H1B people. When you're moving the location, you need to file an H1B amendment. When it comes to the H485 EAD people, if you're moving to Alaska, from Alaska, you're moving to Hawaii, and from Hawaii, you're moving to Florida, no problem. You don't have to report anything to the USCIS. You can file something for address change form. It's called AR11, which is online. It takes about 5 minutes to file it. But as such, you don't have to file any amendment or any I-485J supplement.
Sam says, how does USCIS track if I'm using my H1 or I'm using my EAD? Like, what if I use my EAD for Uber and don't tell my H1 employer? The USCIS doesn't know. There's nothing that gets informed to USCIS by you choosing to use your EAD and working for a second company or a different company. How they will eventually find out is during your green card interview, or if they send an RFE asking for your 5-year employment history. That's quite common, especially when the 485 is pending for a prolonged period of time due to retrogression. So 5 years from now, when your date becomes current again, they may send a request for evidence asking for your employment history. At that time, you do need to disclose if you worked for Uber, and then they will see that you had used your EAD during that time and are no longer in H1B status.
Deepak, can H4 having no visa stamp and passport, but having an approved extension and traveling with the H1B principal applicant who has a visa stamping and the passport, can he come back into the United States? Only if you go to Mexico or Canada and you're coming back within 30 days from the time that you left the country, you can come back. But if you're going to India, even if it's 1 day you spend in India, you're coming back into the United States. If you don't have a passport visa, they will not allow you to come back into the United States. You have to get the stamping. Even if your spouse has the H1B passports, H1B approved in the passport is stamped with the H1B, he or she is allowed to come, but you are not allowed to come.
Govinda says, for the I-140 experience requirement, if I worked a full-time or part-time internship during the school year and got academic credit for it, is it true that this cannot be counted for experience when filing the I-140? Yes, you cannot double dip. So if you did that internship and got academic credit for it, that counts for your degree. So you used that to meet the education requirement, not the experience requirement. You can't then use the same internship to count to meet the experience requirement. It's double dipping, and that is not workable.
Can my wife, who is an H4 EAD, currently she is unemployed, is it okay for her to travel Does she need to carry any documents? Absolutely doesn't need any documents. If whether she is employed or not is irrelevant for her to travel, will not face any problem for her to travel, and does not need any additional documents. Madhav Matkar from Facebook has this question: can someone on H4EAD do two jobs at the same time?
Oh, I just did that one.
Oh, you already answered the question.
Yep. Yogita says, my company has a moonlighting policy and you need to inform them for a second job. So if I'm using a concurrent H1B and they're not direct competitors, do I still need to inform my employer? So it's not really an immigration question at that point, because the immigration rules don't require you to ever inform an employer regardless. You just have to make sure that the concurrent H1B is filed and you're authorized to work for whichever company or companies you're working for. But you do need to follow whatever policy or employment agreement that you signed with the company when you joined. And if you are breaching that agreement or not in compliance with that policy, then the company can take action against you, not immigration action, but something related to your employment, depending on what their policy is. If they find out later that you did this, maybe their policy says they can terminate you for that. So definitely be aware of that from a employment law standpoint, but from an immigration law standpoint, it doesn't really come into play.
My parent lost their Indian passport, which has a B2 visa. Later on, they found the passport, but in the meantime, they got a new passport. Can they travel on the visa which was on passport lost and later found? No, because you reported to the police that you lost the passport. Now you're using that passport. No, I would suggest that you have them go for stamping before they come into the United States.
CG says how to recapture H1B days that are spent overseas. So yeah, anytime you spend outside the US during your 6 years of H1B time can be recaptured at the end. So if you are nearing that 6-year limit and you spent 3 months outside the US, when your employer files that next extension, they can request those additional 3 months. We typically will include a chart that lists all of the days in and out of the country, and we do a calculation that shows exactly how many days you've used of H1B time so far, how many days you have left towards the 6-year limit, and give them what we think the end date should be. And those dates are usually corroborated by the online I-94 travel history. Now all of that is available through the CBP website, so you can use that to verify your dates in and out of the country.
Can a person who has moved to the H4 visa from H1B, can he move back to the H1B once his I-140 is been approved? Yes, he can. That's a very good thing, where you can move back to the H1B once your I-140 is approved, because now you can claim more than 6 years on H1B because your I-140 is approved.
Mohan says, I have 2 APs, one for an EB2 485 and one for an EB3 485. But when I applied for the EB3 AP renewal, USCIS denied it, saying you already have an AP with the EB2 one. Is this denial going to have any impact? No, not at all. That's totally fine. These days, USCIS is taking the stance that they're only going to issue one AP. And so if you already have one that's valid and not expiring anytime in the near future, they'll deny it, even if you have 2 different bases for applying for the AP. So really at this point, you just need one EAD, one AP. You don't have to keep renewing both going forward.
Srikanth, I-140 has been approved and he moved out of the company, and they are not giving him the copy of the I-140 approval. Can he get that thing somehow? There is something called Freedom of Information. Just Google FOIA USCIS. You will be able to get there is an online application, then you can file it. It takes only 10 minutes for you to file it. It takes about 6 weeks for you to get a copy of the I-140 petition that has the record of your I-140 approval. Your I-140 belongs to the company, so they have an authority of not giving it to you. But you can get it online. It just takes 10 minutes for you to get that thing.
Yen says, do we need a really strong reason to expedite a perm case? How can we reach out to a congressman for delay in perm? Unfortunately, perm will not be expedited for any reason. Even if you were to tell them you're going to die tomorrow, if you don't get this perm approved, they will not expedite. DOL never expedites perms. That's been their stance from day one. I've never seen one expedited. That being said, we do have an ongoing lawsuit claiming that their delays in adjudicating the perms are unreasonable. We're not asking them to expedite our perms or anything like that, but we are telling them that the delay is unreasonable and they need to take action on them. But contacting your congressman on a delayed perm will not be useful at all.
Executable has having a very tough question. It's a complex question because it's better to be specific though. Is there any difference between the green card retrieved through different categories apart from conditional and 10-year green card? Now, even for the 10-year green card, so there are many different kinds of green cards. Some of the green cards are been given because you are a political asylum. That means that if you go back to your home country, they're going to kill you or something like that. So technically, there are some conditions. There may be some conditions attached with these things, though. So if you would be very specific, what exactly your green card is, what are you thinking about the conditions, then we can answer it more thoroughly rather than giving. Because green cards are given, I don't know how many different categories. When I last looked into the report, 100 different ways of getting the green card, Emily. The categories are not 100, but at least 50 plus different ways of getting the green card. I don't even know some of those.
Let's see. Sandy says, I have an approved I-140 in the EB3 category. It's been more than a year, but I see that the priority date is wrong on the approval notice. Can we fix it? Yes, depending, there are different ways to fix it. Some may be more successful than others. So the number one place to start, and again, because it's an I-140, only your employer or their attorney can fix it. You can't do anything about it. They can put in a service request for typographic error on the approval notice. It's very likely USCIS will come back and say, hey, this was more than a year ago. We're not going to fix it. You need to file an amended I-140. So that would be the next step your company can take. You could try, they could try ombudsman assistance to get it corrected. It may not even be that big of a deal to get it corrected. If it's very clear, like maybe you have your perm approval that shows this is the date that it was filed and they put a different date on the I-140 approval. When you're filing the 485, you can include the copy of that perm approval to show that the date is indeed incorrect and that they should use the correct date. Otherwise, if it was maybe they didn't port an old priority date, same kind of thing. You can submit both I-140 approvals to show what is the correct date and ask them to make sure they use the correct one in accepting the 485. Sometimes in that situation, you have to get past the mailroom, so it may be worth your effort to actually get it fixed before you file the 485.
Weird and Wacky has this question that on a H4, not on the H4 EAD, can a person work remotely for a Canadian company? The answer is no. If you are in United States, you come under the jurisdiction of the United States. If you're working in United States, even if you're working remotely though, you must have a work permit. So I tell an easy principle for the people is that rule of the butt. If your butt is sitting in USA, you need to have a work permit in USA. Since you don't have a work permit in USA, you cannot work. Now, even if you remotely work, the Canadian government does not recognize the remote system at this point of time. The US government does not, the Indian government does not. Let's say, for example, you're working in Mars. Well, there are some objects that are there in Mars, and let's say you're programming for that Mars object, but you're sitting in United States. You must have a work permit in United States. You can't claim that I'm working in Mars. No, that's not allowed.
Rohit says, once the H1B or the compelling circumstances EAD is approved, can we apply for advanced parole to travel to my home country? Unfortunately, no. Although many EADs and options do come with the option for advanced parole, like TPS or DACA or 485 pending, a compelling circumstances EAD does not have an option to get an advanced parole along with it.
Samreen Sabah, the employer is not willing to share the I-485J. Is there any other way to obtain this document? You can file a Freedom of Information, FOIA USCIS. You type in there, same principle. It takes about 10 minutes for you to fill out. It takes about 6 weeks for you to get that one. You may not need the I-485J supplement for any reason. I don't see why you need it, but just in case if you need it, you just file the FOIA, then it will take care of the thing. Arvindan Nan from YouTube asks this question: is there a need to file an address change with USCIS after 1 year after receiving the green card? USCIS may want to send some things to the old address. Yeah, you can still file the change of address even though you may have not done in the past 1 year. There is something called AR11 form. You can fill something AR11 form online, and based on that, the address change will automatically happen. It takes just 2 minutes to fill the AR11.
Kriti says, my wife's travel record is not showing in the I-94 site. Her last arrival was in 2017. So there's a couple of possible things. Number one, is her I-94 showing in that site? Number two, does she have a new passport now? Does she need to put in her old passport number to get the previous record? Or maybe you're entering her name differently than what they have in their record. So I would start playing around with those things to see if that might be the reason why it's not showing up.
If I have two H1Bs, one is the primary and the second one is the concurrent employment of the H1B. If I lose the primary employment, am I still maintaining the status? We don't know the answer yet. I would strongly recommend that you file an amendment for the concurrent employment to convert that into main H1B. Is there any timeline for the third round of H1B? When the third round for the H1B lottery? Probably somewhere in the December first week is what I'm expecting. Could it be that they will not do anything? There's a chance for it, but I'm expecting in the November last week is already coming. Maybe in the November last week or probably December 1st or 2nd week will be the time.
Yeah, I was looking into the history of that. So obviously we've only had the third lottery once. And when it happened before, it was November 19th that they announced it, which would be around this week. At the same time, when they announced the second lottery this year, it was later than when it normally has been. It was July 27th. So 27 days after the previous round filing window ended. So maybe we're looking November 27th, 28th.
Hopefully so.
Sometime next week.
Yeah. Anything else, somebody?
Oh gosh, guess we're out of time already. So thanks everyone for joining us. Hope everyone has a great Thanksgiving, and we'll be back next week as usual at 5 o'clock on Tuesday.
Thank you very much.